Hello students, we are back with the business law session for B.B.A 5th semester, and we were discussing about the essential called as the competency of the parties to the contract. Who is competent to the contract? In our previous session we had discussed that all persons are competent provided he is a major, he is of sound mind, and he is not disqualified or forbidden by the law. So these persons are eligible. In other words, a minor is not eligible, a person of unsound mind is not eligible, and a person disqualified by law is not eligible for the contract. Now I come to the main question here, the law relating to the minor. What is the law relating here laid down in the act? So it is a 10 marks question from your examination point of view. They will ask you who is a minor and state the law relating to the minor. So this will be the question from your examination point of view. You have to prepare it for 10 marks. So as you already know the meaning of a minor, in other words, we have studied here who is a major. So on that basis we can come to the conclusion who is a minor. So a minor is a person who has not attained the age of 18 years in the first circumstance. Secondly, if he is under the guardianship or the supervision of the court of wards, he has not attained the age of 21 years, from where the majority starts. So until that he becomes a minor. So usual general law is that if he is below 18 years, so we call him as a minor there. So what is the law relating to the minor, we will discuss here. And one decided case we have got here. So we will be discussing that here the case, and that can be asked changing the here the name of the parties. The question may come in your section D for 5 marks. So that is here what we are going to discuss here. So taking here the law that has been laid down in respect of here the minor we are going to study. So totally we have got 8 important aspects that we are going to discuss. First one is agreement with minor is wide ab initio. So the word is wide ab initio. So we have studied what is wide. Wide means the agreement with a minor is wide means here it is not enforceable in the court of law. So when we have studied the types of the contract, you have come to know that here based on the validity, valid contract, wide contract, and wideable. An agreement with a minor is wide, we say. That is, the agreement is unenforceable in the court of law. But there is one more word added, ab initio. Ab initio means right from inception, right from the beginning, the agreement is wide. The law itself here has forbidden any agreement with a minor cannot lead to a contract. It is expressly declared wide by the law itself, an agreement with a minor. So right from the inception, so the agreement cannot here lead to the contract. It is wide ab initio. Right from beginning the agreement is wide here. Ab initio, that is from beginning. It is unenforceable. That is what the law says. So here there is one case about here when this law was laid down. The name of the case is Mohari B.B. versus Dharmadas Ghosh. Mohari B.B. versus Dharmadas Ghosh. This is the case name. Mohari B.B. versus Dharmadas Ghosh. So Dharmadas, a minor, he borrowed 20,000 rupees from Mohari B.B. during his minority. Try to understand the facts, students. Dharmadas Ghosh was a minor. He borrowed rupees 20,000 from Mohari B.B. during his minority and executed a pro note. He executed a pro note here stating that he has borrowed 20,000 rupees from Mohari B.B. That he is indebted to Mohari B.B. of 20,000. The pro note was signed by him. On attaining the age of majority, this was mainly done during the time of a minority of Dharmadas Ghosh. On attaining the majority, Dharamdas here mainly pleaded that he was a minor when the agreement was here entered. Hence, he is not liable for that. The agreement is unenforceable, he stated, because it was done during his minority. And this was brought to the court by Mohri B.B. Mohri B.B. filed a case against Dharamdas Ghosh on the faith of that pronote. And here it was stated that the law that was mainly laid down is that here right from the beginning the agreement with a minor, an agreement with a minor is void. So as Dharamdas Ghosh was a minor here, Mohri B.B. here was unable to recover that amount. He is not eligible because the agreement is itself void. So then the law was laid down. After this, here the case we come across, this was here laid in the law, or it became a rule that an agreement made by here a minor during his minority is not enforceable. Right from beginning it is void. This is what right from the inception. That is why the word has been used. Void ab initio. It is void ab initio. In simple words, here the minor cannot be a promisor. Minor cannot be a promisor. Here the execution of the pronote means he has a promise to pay that 20,000 to Mohri B.B. that. So he is a promisor. A minor cannot be a promisor because of his minority. He is unable to take the rational decisions. He is unable to here come to a proper decision because of his immaturity. So the law is always in the favor of minor. Law is always in the favor of the minor, and hence it has expressly declared any agreement with the minor is void. This is the first rule that is applicable, and the case is Mohri B.B. versus Dharamdas Ghosh. The second one, no ratification on attaining majority. Ratification means here whatever you have done previously, any act, you are going to ratify it, you are going to accept it. Now, no ratification on attaining the age of majority by a minor. So minor, whatever he has done during his minority, so on becoming major he cannot ratify it. He cannot ratify it. Now this is, for example, here Dharamdas Ghosh, he says that during his minority he has executed the pronote. Here on attaining the majority I become here liable to here Mohri B.B. means this is not acceptable. He cannot ratify that which is here void. The matter is itself void there and you cannot ratify it. If you are ratifying it, you are defeating the provisions of the law. So this is not permitted. Once it is void means it is void. You cannot ratify it. So on attaining the age of majority, here you cannot ratify any acts which have been done during the minority. That minor cannot do it. So no ratification is applicable. No ratification on attaining the majority. This is the second important thing to be remembered. No estoppel. No estoppel means this is one of the doctrine in the law we have got. So what the law says is that, what is the doctrine of estoppel? If you have represented yourself here mainly to another, though it is here a false representation you have made, then you are not allowed to go back on your representation. Once you have made the representation, you have to abide by the representation. But so later if you are deviating for them, here deviating from it means you have, the law prohibits it. The law says the doctrine of estoppel is applicable. Here you are stopped from doing it. Once you have given a representation, the other party has believed you and they have entered into an here contract. So here you cannot go back on your representation and you have made the other party here to believe it and enter into here a contractual relations. So doctrine of estoppel is there. But this estoppel doctrine is not applicable to the minor. So minor, though he has presented himself as a major during his minority, so later at any time he has the right to claim that the minority as an excuse. So no doctrine of estoppel is applicable to him. No estoppel against a minor. He can claim the minority as a defense at any time. This is the rule. So usually in an agreement, one representation, once you make it, the other party believes you and enters into a contractual relation. Later on, you cannot go back on your representation. You are stopped from that. You are stopped from that. But a minor, though he has represented himself as a major, here he is here the doctrine is not applicable to him. The doctrine of estoppel is not applicable. He cannot be stopped. He can claim the minority here as a defense at any time. This is what the law says. No estoppel is applicable. These are the things related to the minor, what the law says. Here, each law should be explained in 3 to 4 lines. That is, maximum here 3 to 4 lines you have to give each doctrine. Wherever possible, try to give an example. Minor cannot be a partner. This is another very important thing. Usually, here, you know that a partnership is established through the agreement between two persons. Agreement between two persons leads to the partnership. So when partnership is made, here for example A and B, they enter into an agreement to run a business through the partnership firm. So it is the agreement is the basis for the partnership, and a minor cannot here make an agreement. So here minor cannot be a partner. The use of the word is he cannot be a partner, but with the permission of other partners he can be admitted to the firm for as a beneficiary. He can take the benefits of the firm. That too with the permission of other partners, a minor can be admitted to a partnership firm for benefits only. He is not liable for any other things. So he is called as a beneficiary. You cannot call him as a partner. Suppose if anyone asks you, can a minor be a partner? Here with the permission of other partners he can be a partner. If you say it is wrong, because you cannot use the word partner to him. Partner must have that here the capacity to enter into a contract. Here a minor is not having, because he is below 18 years. So here the agreement he enters is void, as you already know what we have discussed. So here in this case, here the agreement always leads to the establishment of the partnership firm. So here a minor cannot be a partner. He can be admitted to the benefits of the partnership by the agreeing consent of all other partners. So he can be called as a beneficiary. In partnership firm, minor can be beneficiary but not a partner. This is the another law relating to him. Minor can be an agent. So this is a very thing you know that. Here section 185 of the Indian Contract Act says, in the creation of the agency, any person can create. Agency, he may be any person. Here the agent may be any person there. So it is they have not specified that he must be here a major. The person who is appointed an agent. Usually who is an agent? We say he is acting for another person. He is representing another person to the public at large. So what is he is just an intermediator. Agent is an intermediator. He acts as an intermediator between the public and his master. The master is called as principal and the agent. So the principal appoints a minor as an agent. Here it is valid, because any loss caused to the principal, he cannot hold the agent liable. It is an act of an agent is an act of the principal. Whatever agent does, here principal is liable for that. So whatever wrong it is done by agent, he will be responsible. So he can appoint a minor also. If he has the confidence in that person, he can appoint a minor also. So there is no restriction. So what the law says, a minor can be an agent. He can be appointed as an agent. So it is the discretion of the principal to appoint him. But he must know that he cannot hold here the agent liable for any act done on his behalf. So agent will be acting on behalf of the principal. If any loss is sustained by the principal, here the agent is not liable there. So that is what in general rule also it is the same thing. Even though that agent is a major and is acting for a principal, the act of an agent is act of the principal. So at no time a principal can hold here the agent liable for the act done on his behalf. So let him be a major or let him be a minor. So a minor can be appointed as an agent. Likewise, a minor can be a shareholder in a company. He can be a shareholder. He can purchase the shares here and he is represented by his guardians. So it is through the guardian. Here he can purchase the shares in his name. So he can be a shareholder, but he will be represented by the guardian. A major will be representing him. And here this mainly the thing you have to remember, the company, in a company, here the shares can be issued in the name of the minor represented by so and so as a guardian. So usually this is there. Even for example, when we go to a bank, can a minor open an account in a bank? The answer is yes, he can open, but there must be one person representing him as a major and as a guardian. So you will find represented by, they will write. They will be here, if a minor account is opened, represented by, that is always there. So here the minor is represented by the guardian there. So when the shareholder is there, the shareholder here he can purchase the shares in his name, he will be represented till he attains the majority by the guardian. So that is shares can be issued in his name. This is another law related. Minor can be a promisee. Now this is a vice versa. I have just explained in the first aspect what we have seen. Minor cannot be promisor in agreement. He can be a promisee. He can be a promisee. For example, just I will be giving you. A major borrows 20,000 rupees from B, who is a minor. And A has executed a pronote in favor of B. B is a minor, remember. He has executed a pronote in favor of B, stating that he has borrowed 20,000 rupees and after 6 months, 1 year, he is going to return it. Remember, B is a minor. He is a promisee. Who is a promiser? A is a promiser. He has promised. The pronote is executed by him in favor of B, who is a minor. So minor is a promisee here. Later, A says that here as the agreement was during the minority of B, hence it is not enforceable in the court of law, and it was brought to the court. The court held that here a minor cannot be promisor, but he can be a promisee. Usually what it says that here the law is there to protect the minor. So during his minority, because of his immaturity of the mind, he cannot be exploited. He cannot be here deceived. No fraud should be committed against the minor. So the law is always in favor of the minor. So what law says is that he can be a promisee. And in this case, the court said that A is liable to pay 20,000 rupees to minor. Because in this case, that minor was a promisee. So minor can be a promisee in the act. He can be a promisee there. So like this, here this is another most important thing you have to note there. Then the last one, minor is liable for the necessaries supplied during the time of minority. So now where you can hold the minor responsible. So it means that a minor cannot be responsible for anything. Here whatever he does in the minority case, when he is a minor, sometimes here the law is very stringent here. So it says that if any necessaries are supplied, to the minor during his minority, then here the minor is liable to here pay the value of the necessaries supplied during the minority on attaining the age of majority through his property. This is what the law says. So the law says that here minor is liable on attaining the age of the majority. The person who has supplied the necessaries to the minor during the minority can claim the price of the necessaries. He can claim the price of the necessaries. Now the question arises, how to determine the necessaries? So it is depending upon the person's here status in the society, the economic status. So this should be counted into determine here what are necessary supplied to a minor. So supplying a luxurious car here is not a necessary. This is not a necessary. So what are the necessary things which are very essential? Necessary means which are very essential here for the person's here growth, like food, education, books, shelter, clothing. These can be all necessaries. So any person who supplies these necessaries to a minor during the minority, here later when the minor attains the majority, he can claim the prices of that here the necessaries he has supplied during the minority. In this case, the law says yes, minor's property is liable. Minor's property is liable to pay for the price of the necessaries that are given to him during his minority. Not only that, even sometimes here the minor and his dependents who are supplied with the necessaries, here that is also counted. This is also mainly counted. Not only minor, but even the dependents of the minor who is supported by the necessaries, even that becomes the part. Here that is mainly the price has to be paid when the minor attains the majority there. So that is the law here that has been laid down in the Act. This is what we have got here, the various laws relating to the minor. Relating to the minor, these are the various laws which have been mainly mentioned in our Indian Contract Act and other ancillary acts. So even if you see that even the punishments, criminal punishments for any crime that is committed, the minor is exempted there. Here he is not punished as other criminals are punished. Usually the reformative activities takes place. The reformative activities take place. He is sent to the reformation school or the Boston schools. So that is usually referred as the juvenile delinquents. They are known as the juvenile delinquents. So as the criminal, the punishments are there, it cannot be applicable to the minor. But in some civil wrongs like the torts, here the minor will be liable there. So it is always seen that the law has been very protective to a minor and his interests are protected. But sometimes a minor can be held liable under few circumstances. Otherwise, the law is very here mainly protective in nature towards the minor's rights. So this is the law relating to the minor. In your examination, you can get this question for 10 marks. So keeping this here, in our next session, we are going to start with here who is a sound person, or in other words, who is an unsound person and who are the persons disqualified by the law, who cannot enter into a contract. So these two aspects I will be discussing in my next session.